Hi, and welcome to this IFSEA podcast, chaired by me, Wanu Sanda. I am a senior associate at CM Murray, and I'm delighted to be joined by my panel from this year's IFSEA conference. I've got Brian McDonough from Shering and Lodgen, who is a US employment lawyer. I've got Persephone Bridgman-Baker from Carter Ruck, a PR specialist. Jasvinder Nakwal from Peters & Peters, who specialises in white-collar crime. And Jason Massamore from Cobra & Kim, who is also here to give us the US angle from a white-collar crime perspective. So thank you everyone for joining today. And we were just going to discuss some of the issues that came up in our session. We were covering cross-border executive investigations, and we were looking at the risks, the strategies, and reputation issues for senior executives. So, kick off, we had a hypothetical scenario, but for the purposes of this podcast, we want to keep it fairly high level and just discuss some of the issues that a senior executive might encounter when they've been told that an investigation is going to be underway internally. And then we're also going to discuss some of the issues that might come up after regulatory bodies get involved or criminal bodies get involved. So to start us off, Brian, we've got a senior executive situation where they have been involved or been notified of an investigation. What sort of major sort of issues should they be thinking about as soon as they've been notified?
Yeah, so I think, for as an employment lawyer representing senior executives, on the legal side, I feel like we're often like the front line, right? Because you represent executives throughout their careers, and the good and the bad. It might be the negotiating the in deals, it might be negotiating the out deals, contentious litigation, and everything in between. So oftentimes you get the first call, and you have a panicky executive. There's notice of investigation. The first step for both counsel and the executive is to not panic, right? Not to slow things down to the extent you can. Try as best you can to get the lay of the land. I never want to see executives carving out hard and fast positions like refusing to cooperate out the gate. Kind of cliche things like, I'm not talking without my lawyer present. You need to kind of really slow down, gather as much information as you can. And oftentimes that becomes the role of counsel, because, certainly on the US side, as far as, you're not always presented in the context of an internal investigation with a nice, clean written report. Here are the allegations. Here's what we think don't know. Here's everything we have. It usually doesn't unfold that way. So oftentimes, having counsel involved, kind of working, trying to gather information, counsel to counsel, talking to in-house counsel, trying to get a better understanding is the first approach. And the other key thing is not all investigations or allegations are created equal. And, really it's the appropriate legal strategy is in large part, going to be dictated by the nature of what we're dealing with here. Now, in our hypo, at the conference, there was pretty significant allegations of bribery, corruption, money laundering. Certainly if you're representing the executive that is the target of that, my first call is going to be to a white collar person, and the strategy in that, to cooperate, not cooperate, might be very different if this is somebody who's more has some knowledge, but is more of a fact-based witness. Are the allegations that, this person was aware of it, but didn't necessarily engage in any wrongdoing themselves. So in a large part, the legal strategy might be dictated by, the specific allegations.
And then you raised that point about not having, I guess, a knee-jerk reaction to what the individual might do. It's a serious, in certain cases, serious allegations being made, potential ramifications for career, liberty, maybe in some cases, and you can understand why people might want to take particular actions. But as you've just mentioned there, getting white collar crime input early stage is really important. And as when you're brought in at that stage, what sort of considerations are you taking into account in terms of an individual cooperating or not cooperating?
So first of all, I agree, Brian, don't panic. That's a message for the individual. And also the information gathering. So one of the considerations is actually, how is the executive being treated by the company that's carrying out the investigation? And at that stage, probably not that much is known, or there are bits of information here and there about what might or might not have gone on in terms of any conduct. So, and bearing in mind that senior executives' status may change as the facts unfold. So at that very early stage, any fact-finding that can be done by those acting for the senior executive through the company, so maybe ask for a pre-pack of information or disclosure of any relevant emails or documents that the company wants to talk to the individual about, would give a good, hopefully give a good heads up on what the individual is wanted to be spoken to about. And then, as I also say, their status may not be clear. They may be being treated as a witness or someone who has information that would be helpful to the company, or they may be seen as a potential suspect, or someone who may be considered to have been at the center of any wrongdoing. So for that scenario, considering it's really important to consider in advance whether any questions are going to be answered, and on the part of the company, their own lawyers should, as a matter of UK ethics, be considering whether the individual needs separate representation, and if they are to be treated as someone who might have committed some wrongdoing, then to give them that opportunity to take advice, but also be prepared for that person not wishing to answer questions that then may incriminate them in some shape or form. So there are various factors to balance out here at that first stage.
That's interesting. And Jason, what about from your perspective with your kind of US experience and background?
Yeah, I guess a couple of things. I mean, I'm trying to suss out at the outset, how serious of a matter this is and whether or not it's going to set off bells and whistles in the DOJ, because the DOJ has strict instructions from the very top of the organization to go after individuals, every single individual who was involved, and they'll stop at nothing. So, early on, if you get a whiff that might be a possibility, that it's a case of high interest, it's a publicly traded company in the U.S., it conducts a business in some sort of area that's interesting to the human beings that sit in prosecutors' offices and are looking forward to their private sector jobs and want to make a name for themselves, the alerts start going off, and you start figuring out how this is going to look from beginning to end, and then starting to educate the client about the process so you can sort of choose your strategy. I do think, you want to start off appearing very cooperative and sort of making a case to in-house counsel how you can be an asset, but you have to be ready for a potential knife fight at the end.
Yeah, flip. And for Stephanie as well, from a PR perspective, at an early stage, you might not know how it's going to turn out, whether or not you are going to be a witness or a main subject. What sorts of reputation management issues should senior executives be thinking about at that stage? We spoke about some of the sort of high level issues for them to look out for. And do you mind covering that?
Sure. So it's a pleasure when I'm instructed at this stage of the process, because it makes it so much easier to try to control the narrative before things are published in the press rather than afterwards, although there are ways and means of doing both. And when somebody is being investigated, if they're being investigated by a public body or in other certain circumstances, then they will have a prima facie right to privacy and the scope of that investigation and the fact of that investigation. And that's something which at this stage I'd be trying to keep a very close eye on. It may not bite in the context of a company investigation, and if something was leaked to the press and there was some public interest, then perhaps there could be scope for publication. So I'd have an eye on that. At this very early stage, and I think this syncs with what the other advisors are saying, I would want to see if there's a possibility to have an aligned approach between the employer and the senior executive. That might be possible at this early stage. And as you say, you don't necessarily know how things are going to go. So if you can both be singing from the same hymn sheet at that early stage of the process, then it can make life easier.
Yeah, I can see how that would be the case. And things can then move on quite quickly. So we discussed in our session how things could change once you do have regulatory bodies involved, potentially, criminal prosecutions on the horizon. In a situation where that has changed, the individuals become subject of the investigation and actually pushed to the forefront in front of the regulatory bodies, the sort of issues that they have to consider and how they approach strategy will also change. So Brian, once that has happened, would you say that your advice or your approach to things would change as well?
I mean, I think if we're at the stage where, this is, reached the point where there's a governmental investigation, I think some of the common themes, I think you want to the extent a lot of times the best thing for the executive is to stay closely aligned with the company to the extent they can. But as we've heard, it might be helpful from a PR aspect or otherwise, but, as we've kind of heard there might be a point in time where, you need to start looking out for number one here, right? So, like the classic lawyer answer, it really depends, and there's, you can't black and white it, cooperation, not cooperation, it comes in many forms, and again, sizes. And, I never, certainly if I'm having concerns, you're never saying no, but it's, they may want you to do one thing. It's like, well, maybe it's a different approach or different. No, I'm not saying no, of course I'm cooperating. I'm continuing, but, kind of, it may look at a point where it's, protecting your own interests. And that's sometimes, where it depends, like reading the tea leaves, how serious we're talking here. If the prospects of what is the primary goal here? If the primary goal is, to keep the senior executive out of jail, freedom, things like, well, what about my millions of dollars in, equity, that might have to take a back seat if your primary goal here is to keep somebody out of jail. There are other situations where, for the executive, it might end badly, but it's more about trying to mitigate the fallout, whether it's from a PR perspective, so they can kind of pick up the pieces and move on with their career. If this is a situation where, the employment is being terminated, but then it's a question of, okay, what about deferred compensation? What is already vested or is on the cusp of vesting? Is there a possibility of protecting that?
Yeah, and you mentioned earlier on, wanting to have legal representation, for example. At this stage, is this something that you would personally be pushing for if you hadn't been given it during an?
Oh, certainly. If we're at this stage, yes, one, pushing for it. Two, for many U.S. executives, a lot of times it might be driven by contract specific, but oftentimes at this kind of stage, it's likely to trigger kind of defense indemnification, whether it's under contract, insurance policies, or company bylaws. In my experience, a lot of point in time, it'll be not necessarily at the very beginnings of the internal investigation, but certainly by this stage, it's likely triggered.
And just picking up on that point about, sort of reading the tea leaves and then having sort of overarching objective, and if that is to, I guess, leave the profession, if it's a regulated profession, and try and move on to something else, there might be a question around whether or not that's possible. But even after they've dealt with the immediate employment issues, they might still have issues with that regulator. In those circumstances where an individual is not just dealing with their employer, they're now dealing with the regulator, do they have additional kind of obligations and issues to be thinking about?
In relation to the regulator?
In relation to the regulator. So I think before we were discussing, you know, do we want to cooperate? Is it going to assist us? But the regulator's involved now. I mean, we probably have a little less latitude.
Absolutely. So yes, you're right. In dealing with the employer, then there are consequences often for not cooperating with the employer, and which could potentially lead on to dismissal. But weighing up the priorities when things become even more serious and there's an enforcement agency involved, unless it's a criminal enforcement agency, then it is possible to be compelled to give an interview, to be interviewed, but usually that's if the enforcement agency is treating the individual more as a witness, but as a suspect. An individual does have rights under that process as a suspect. They would have to be cautioned and then interviewed, and in that context could choose to answer questions and give a full interview, could choose to remain silent and give no answers to any questions, or could, for example, prepare a statement which is handed over and then no further questions are answered. So it very, very much depends on the evidence and also the individual's version of events. And so there are various matters to consider at that point, and it very much depends on what the individual's position is at that point.
Yeah, and I think this might move us on to an interesting point that came up in our discussion at the conference around the status of that interview and how someone like Jason, for example, might use that in the US to assist the individual if they're potentially going to be prosecuted there as well. So Jason, I just wanted you to comment on how you would view an individual being compelled to give a statement to a criminal body in the UK.
Right. So
UK regulator.
As everybody might know, you know, in the US, it's a lot different. There's an absolute and total right to remain silent. So once somebody in the chain has been interviewed under compulsion in the UK or in another jurisdiction, that presents an opportunity down the line if you're defending somebody who goes to trial in the United States. If that information somehow comes to cooperators who are assisting the DOJ, that infects their case. And in fact, there was a very famous case a couple years ago where the traitor's convictions were reversed because the cooperator had gotten to review and learn about what the defendant was compelled to say in the UK, and it ruined the case for the prosecutors. You know, what I'm looking for is, you know, at some point I'm assuming, okay, worst case scenario, there's going to be a trial in the US. What's that going to look like? And then I reverse engineer sort of strategies designed to absolutely destroy that trial in any way possible, ethically permitted, of course.
Ethically permitted. I think I recall you saying that if you were dealing with an elderly potential suspect, you might deal with them in a particular way by making sure that they are, is it last?
Well, in a series of clients who are like family members or have strong personal bonds, remember, a choice a lawyer might make is lawyers, we're all risk averse, but clients have a range of different concerns that they're thinking about. And so as Brian brought up, what's the objective? So when you have a group of closely related people, you could run in an elderly or a sick defendant. I know this is getting really specific, but you could run an elderly or sick defendant in internationally to US and insist on a speedy trial while the others contest jurisdiction and try to get a trial very quickly. It would work in certain jurisdictions. And then you get all the material, all the evidence, everything comes out. And the reason you would pick in that circumstance an elderly or sick person might think this is a rational way to behave is because at the end, you know, their physical conditions are actually going to result in a reduced sentence, maybe not even serve any time, even if they're convicted. So there would be reasons to do it. Of course, there'd be other reasons not to do it if you know, perhaps they don't have a long life expectancy, running out the clock and just staying in your home country. So it really depends, but there's just such a wide range of strategies that can be considered once you account for the fact that there's going to be a trial at some point.
Yeah, that's so interesting. And just to come to you, Persephone, as well, just to wrap this all up. So we, had the situation where the external regulators are involved, or criminal prosecutors are involved. It's at that stage as well that sometimes information leaks, and whether or not the individual's has done what they're accused of doing, they could be tarnished in the eyes of the public. And if you're getting involved at that stage, what are your sort of key, what's the key focus? What sort of action can a senior executive take if information's being leaked at that stage?
So again, while anyone is still under investigation, whether that's by a law enforcement body or by a state entity like the police, they still have a reasonable expectation of privacy in the fact of that investigation. And there's been a recent case against Bloomberg in that regard, to try to prevent publication of the details of the case. And that's a case where the claimant's name was anonymized, so all of the proceedings were kept private. And that's something which people should be thinking about in those circumstances where they haven't reached the point of charge, whether there's any pre-publication relief that can be sought, has to be done relatively urgently. But these are the sorts of matters where if a leak happens and we find out about it at midday, we can be in court by 4 p.m. having it dealt with, or faster if we need to be. And so that's really important to remember up until the point of charge. Now, if an individual is charged with a criminal offence, or if there's a conclusion to the investigation, then that right to privacy doesn't entirely evaporate, but is very likely to fall away quite quickly. And so again, there'll be very different considerations there about how one deals with the fallout of that at the point when a charge has been put in place.
Well, thank you, all of you. I think that's been really helpful, just giving us some nuggets of information for senior executives to think about if they're caught up in these sorts of cross-border investigations. And there are so many different permutations of strategy and risk, and we can probably go on and talk about this for a lot longer, but we will end it there. And thank you to everyone for listening. To continue the conversation, please do join our LinkedIn IFSEA group. We would love to hear and discuss your views further. And last, it's just for me to say thank you to all of my wonderful panelists.
Thanks very much.
Thank you.
Take care.
Thank you.